Welcome to HOA Rulebook. Keep your boots on for this one. You failed inspection, and I am charging the re-inspection right now. Patricia Clark screamed that I was obstructing snow removal, and she was escalating to towing for winter operations. She stood in my driveway at 7 in the morning, breath fogging in the pre-dawn gray, pointing at my truck like it was a crime scene. Snow swirled around us, collecting on her clipboard sleeve. I had parked my truck in my own driveway tucked against the garage door, 2 feet inside my property line. The plow had already gone through hours earlier. There was no obstruction, no emergency access issue, no safety hazard. She did not care. This is Newark, Delaware, in the Landing at Riverstone Landing Association, a neighborhood where everything requires a form and the form requires another form. I am a municipal code researcher who reads ordinances for fun, so I know how the rules actually work. Patricia is the Design Review Board Vice Chair who blocks approvals out of spite, and she had decided my property was her personal enforcement laboratory. The conflict started 3 days earlier when she walked past my house during the first heavy snow of the season and saw my grill cover with snow on it. She declared it unsightly storage, cited an emergency winter aesthetics provision I had never heard of, and slapped me with a $75 fine before I even knew there was an issue. I ignored the notice because it was absurd. She escalated. Now she was threatening to tow my truck unless I moved it immediately, even though the street was clear, the driveway was mine, and the HOA has zero authority over private driveways. I told her that. She said the rules changed during snow emergencies, and I had 20 minutes to comply or she would call the tow company herself. I asked to see the emergency rule. She tapped her clipboard and said she did not need to show me anything because the board had voted on it yesterday during a closed executive session. I asked for the meeting minutes. She said they were not public yet. I said that sounded illegal. She leaned closer, her voice dropping into that cold, satisfied register. If you want mercy, move somewhere without an HOA. I stepped back and pulled out my phone to record. She immediately turned her back and walked toward her car, saying she was documenting my refusal to cooperate and that I would receive a formal violation notice by the end of the day. I moved my truck into the street to avoid the tow threat, then spent the rest of the morning digging through the HOA covenants and Delaware Title 25 to confirm what I already knew. There was no emergency driveway rule. There was no executive session vote. Patricia had invented the threat to force compliance, and when I did not fold, she pivoted to a new angle. The formal notice arrived that afternoon, taped to my front door in a plastic envelope. It was not about the truck. It was about the grill cover again, plus 2 new violations I had never heard of. Failure to remove snow accumulation from decorative yard elements within 24 hours of snowfall. Unsecured winter storage visible from the street during daylight hours. Both violations carried $75 fines and a reinspection fee of $50, due within 10 days or the fines would double and the HOA would place a lien on my property. The notice was signed by Patricia, dated 2 days earlier and marked as a second warning. I had never received a first warning. I called the management company. They told me Patricia had submitted the violations through the compliance portal and they were processing them according to standard procedure. I explained that I had not received any first warning and that the violations were fabricated. The rep said I could file a dispute within 7 days by submitting a written appeal with supporting evidence, and that appeals were reviewed by the Design Review Board. I pointed out that Patricia was on that board. The rep said I could request a hearing in front of the full HOA board if I was not satisfied with the design review decision, but that required a separate form and a $50 hearing deposit. I said this was a shakedown. The rep said the fees were in the covenants and she could not waive them. I asked for copies of the compliance portal logs showing when Patricia submitted the violations. She said those records required a formal request under the association records policy, and that I would need to pay a copy fee of 25 cents per page and wait 30 business days for review. I hung up and started building a binder. I printed the covenants, highlighted every section related to enforcement procedures and notice requirements, and pulled the weather data for the day Patricia claimed she issued the first warning. I took time-stamped photos of my grill cover, my driveway, my front yard, every angle that showed there was no safety issue and no actual violation of any rule that existed. I documented every interaction with Patricia, every notice, every phone call with the management company. I labeled it all in a binder with tabs marked Storm 1, Storm 2, Storm 3, even though we had only had one storm so far. I wanted room to expand because I knew this was not going to stop. The second storm hit 4 days later. I cleared my driveway and sidewalk within 2 hours of the snow stopping, salted the walkway, piled the snow neatly along my property line away from the street. I moved my grill into the garage and covered my outdoor furniture with tarps that I secured with bungee cords. I did everything by the book, more than the covenants required, because I knew Patricia was watching. She found a new angle anyway. The next morning, I found an orange cone in my driveway with a laminated tag attached. Violation. Snow pile placement obstructs drainage flow. Remove within 12 hours or face emergency removal at owner expense plus administrative fee. The tag was signed by Patricia and time-stamped at 6 in the morning. My snow pile was 3 feet from the curb, neatly stacked, nowhere near a drain. I took photos, pulled the cone, and threw it in my garage. 2 hours later, Patricia knocked on my door with a security guard from the clubhouse hovering near the end of my driveway. She said I had removed HOA property, and that constituted theft. I said the cone was not HOA property, and even if it was, it had no business in my driveway. She said the cone was part of the Winter Operations Enforcement Program, and I was now facing an additional violation for interfering with snow management. The security guard looked uncomfortable. I asked him if he had placed the cone. He said no. I asked Patricia who authorized her to place cones on private property. She said the board had granted her emergency enforcement powers during active winter weather. I said I wanted to see that authorization in writing. She said I could request it through the records process and pay the copy fees. I said this was harassment. She smiled. If you are enjoying this HOA nightmare, hit that like button and subscribe for more stories where the bad guys actually lose. I do not need proof. I have paperwork and vibes, Patricia said, tapping her clipboard. The security guard shifted his weight and looked away. I told Patricia to leave my property. She said she was on HOA Common Element sidewalk, which technically extended 3 feet from my front door according to the plat map. I closed the door and called the management company again. This time I got a different rep. I explained the cone incident, the fabricated drainage violation, the escalating harassment. The rep put me on hold for 6 minutes, then came back and said the design review board had submitted a recommendation to the full board to place my property on the enforcement priority list due to repeated non-compliance and a pattern of hostility toward association representatives. I asked what that meant. She said it meant any future violations would carry automatic doubled fines and mandatory hearings. I asked when this recommendation had been submitted. She said it was submitted that morning, which meant Patricia had filed it before she even came to my door. I asked how I could appeal. She said I had to file a written dispute within 7 days, but the enforcement priority designation would remain in effect during the appeal process unless I requested an emergency stay, which required a separate form and a $100 deposit. I was rebuilding my finances after a bad year and I could not absorb bogus fees. Every dollar mattered. The HOA was padding the fines with mystery winter surcharges, reinspection fees, administrative fees, hearing deposits, copy fees, and now priority enforcement penalties that did not exist in the actual covenants. I pulled my binder and started drafting the dispute letter. I documented every notice, every conversation, every timeline inconsistency. I included photos, weather data, and highlighted covenant sections that proved the violations were either fabricated or procedurally invalid. I cited Delaware HOA law showing that enforcement actions required proper notice and that retroactive designations without a hearing violated due process. I kept it clean, factual, and legally airtight. I mailed it certified with return receipt and emailed a copy to every board member I could find an address for. The management company lost my dispute packet. They claimed it never arrived. I sent them the tracking number showing it had been delivered and signed for. They said they would look into it and get back to me. They did not get back to me. I called again a week later. A different rep said they had found the packet but it had been misfiled, and they needed me to resubmit it because the original was damaged and unreadable. I said that sounded like obstruction. She said if I did not resubmit within 3 days, the dispute period would expire and the fines would be considered final. I asked to speak to a supervisor. She said supervisors were only available by appointment, and the next available slot was in 2 weeks. I resubmitted the packet by email and certified mail, and I copied a local mediator I knew from work who had helped me understand HOA dispute processes during a previous job researching municipal compliance frameworks. The mediator called me 2 days later. His name was Roger, and he had worked with HOA disputes for 15 years. He told me the loss and damage excuse was a common delay tactic, and that I should document every interaction with timestamps and witnesses. He said the enforcement priority designation was legally questionable because the covenants did not provide for it, and that if the board tried to enforce it without a proper hearing, I could challenge the entire action as ultra-vires. He also told me to check the meeting minutes archive for the executive session where Patricia claimed the board had voted on emergency enforcement powers. He said if that vote never happened, everything she had done since the first storm was void, and the board could be personally liable for the fees. I went to the clubhouse that afternoon to request the meeting minutes. The office was closed even though the posted hours said it should be open. I tried again the next morning. The office manager, a tired-looking woman named Linda, told me the minutes for the last executive session were not available yet because they were still being reviewed by the board attorney. I said executive sessions were supposed to be limited to specific topics and that enforcement policy was not one of them. Linda said she did not make the rules. I filed a formal records request in writing, citing Delaware Code Title 25, Section 81-112, and asked for all board meeting minutes, executive session agendas, and compliance portal logs for the past 6 months. Linda said the request would be processed within 30 days and that I would be billed for copies at 25 cents per page plus a $15 processing fee. The third storm hit that night. It was a heavy wet snow that buried everything under 8 inches and knocked out power to half the neighborhood. I cleared my driveway at dawn and salted my walkway. I moved my trash cans into the garage because I knew Patricia would find a way to weaponize them. I shoveled my sidewalk all the way to the street and cleared the area around the fire hydrant near my property line because I had read that was a county requirement. I took photos of everything with timestamps. By noon, Patricia was back. She said I had created a public hazard by clearing snow onto HOA common property. I said I had piled the snow on my own property line, exactly where the covenants allowed. She said the property line was under dispute and that the HOA was claiming a 2-foot easement for snow management purposes. I said that was insane and not in the plat. She said the easement had been established during the original development and that I would have to request a survey if I wanted to challenge it. I said I was not paying for a survey to prove something that was already recorded with the county. She said then I would have to accept the violation and remove the snow immediately. I asked where I was supposed to put it. She said that was my problem, not hers. I called Roger. He told me to take detailed measurements and photos of the property line and the snow piles, and to request a copy of the plat map and any recorded easements from the county. He said the 2-foot easement claim was almost certainly fabricated, and that if Patricia tried to find me over it, I could challenge the action as a fraudulent taking. He also told me the HOA claims my appeal must be filed within a short winter window, and today is the last day, and that I should file immediately even if the management company had not responded to my earlier dispute. He said the window was probably in the covenants as a way to trap owners during the busy holiday season when people were not paying attention. I checked the covenants. Roger was right. Emergency enforcement appeals had to be filed within 14 days of the final violation notice, and today was day 14. I had filed my dispute 8 days ago, but the management company had not logged it as an official appeal because I had not included the hearing deposit. I drafted a new appeal, attached copies of everything I had sent before, included a check for the $50 deposit, and drove to the clubhouse to hand-deliver it. Linda was gone. The office was locked. A sign on the door said the office would be closed for the rest of the week due to storm recovery. I slid the envelope under the door, took a photo of it lying there with a timestamp, and emailed a copy to the management company, the board, and Roger. Patricia escalated again the next day. I received a notice that my property was being placed under immediate lien threat due to non-payment of outstanding fines and fees. The total was now $875, broken into 9 separate line items with descriptions like winter operations administrative surcharge and emergency compliance review fee and priority enforcement penalty adjustment. None of the line items matched the original violation amounts. The notice said I had 10 days to pay in full or the HOA would file a lien with the county and begin foreclosure proceedings. It was signed by Patricia and countersigned by the board president, a man I had never met or spoken to. I called Roger. He said the lien threat was premature and probably unenforceable because I had filed an appeal and the fines were still under dispute. He said I should respond in writing, cite the pending appeal, and demand that the HOA place a hold on all collection actions until the appeal was resolved. He also said I should file a complaint with the Delaware Department of Justice Consumer Protection Division because the mystery fees looked like an illegal kickback scheme. I did both. The DOJ sent me an automated reply saying they would review my complaint within 60 days. The management company sent me an email saying my appeal had been received, but that the hearing could not be scheduled until the Design Review Board completed its investigation, which could take up to 45 days. I was stuck. The lien deadline was 10 days away. The appeal was in limbo. The fines were compounding with new surcharges every week. Patricia had manufactured a paper trail that made me look like a serial scofflaw, and the management company was slow-walking every process to run out the clock. I needed leverage, something that would force the board to stop and actually look at what Patricia was doing. I started digging deeper into the meeting minutes archive, the compliance portal logs, and the enforcement history for other properties in the neighborhood. That is when I found it. The twist that changed everything. The management company had been backdating winter notices to manufacture late fees. I pulled the compliance portal metadata and cross-referenced it with the weather data and the delivery timestamps on my certified mail receipts. Patricia had submitted the first grill cover violation on the same day she claimed she issued a warning, but the portal timestamp showed she had backdated the entry by 3 days to make it look like I had missed a deadline that never existed. She had done the same thing with the second storm violations, backdating the cone placement violation by 24 hours so it appeared I had been non-compliant for longer than I actually was. Every fine, every surcharge, every escalation was built on falsified timestamps and invented deadlines. I pulled the full set of compliance logs for the past 2 years and ran the same analysis on every property in the neighborhood. Patricia had done this to at least 12 other owners, all during winter months, all with the same pattern of backdated entries and escalating surcharges. The management company had processed every fake deadline as legitimate, collected the fees, and kicked a percentage back to the HOA General Fund as administrative cost recovery. It was a systematic fraud scheme, and Patricia was using her board position to target anyone who pushed back. I called Roger and walked him through the findings. He told me this was bigger than a dispute over snow piles and that I needed to treat it like a legal case. He said I should document everything, organize it into a clear timeline that showed the backdating pattern, and present it at the next board meeting as a formal complaint. He also said I should bring copies for every homeowner who attended because this was not just my problem, it was everyone's problem, and the board could not bury it if the whole neighborhood knew. The board meeting was scheduled for 2 weeks out, the week before my lien deadline. I spent every evening building the timeline. I printed the compliance logs, highlighted every backdated entry, cross-referenced them with weather data and delivery receipts, and laid it all out in a binder with tabs showing the pattern across multiple properties and multiple storms. I made copies for 30 people. I practiced presenting it in under 5 minutes because I knew the board would try to cut me off. I also filed a pre-meeting records request asking for the executive session minutes, the board vote authorizing Patricia's emergency powers, and any contracts or fee agreements with the management company related to winter enforcement cost recovery. I knew they would not produce the records in time, but I wanted it on the record that I had asked. The fourth storm hit 3 days before the meeting. It was a blizzard, 14 inches of heavy snow with drifting and near-zero visibility. The county declared a snow emergency and banned all non-essential travel. I cleared my driveway twice, once during the storm and once after it stopped. I documented everything with photos and timestamps. I stayed inside and worked on the timeline. Patricia did not show up during the storm, but the morning after, I found a new notice taped to my door. Violation: failure to maintain emergency access during active snow event. Immediate fine of $150 plus emergency snow removal surcharge of $75. The notice was dated the day before, during the height of the storm, when travel was banned and no one could have physically delivered it. It was the most blatant fake yet, and I gave her a small thank you, because she just handed me leverage. I added the new notice to the timeline and highlighted the travel ban order from the County Emergency Management Office. I printed a side-by-side comparison showing the notice timestamp versus the ban period. I made extra copies. I was ready. The board meeting was held at the clubhouse on a Tuesday night. The parking lot was half full, maybe 20 homeowners in the room plus the 5 board members and Patricia sitting at the front table with her clipboard and her clear plastic sleeve. I sat in the back with my binder and my stack of copies. The board president, a gray-haired man named Tom, called the meeting to order and started with routine business: budget report, maintenance contract renewals, holiday decoration reminders. 15 minutes in, he opened the floor for owner comments. I stood up. I said I wanted to address the winter enforcement practices and the escalating fines that were hitting multiple properties in the neighborhood. Tom said I could speak for 3 minutes. I said I needed 5. He said 3 was the limit. I said fine, I would summarize and distribute the full documentation. I walked to the front and handed him a copy of the timeline. I handed copies to the other board members, to Patricia, and to every homeowner in the room. Patricia's face went pale. Tom flipped through the pages and his expression tightened. I laid it out. The backdated compliance logs, the falsified deadlines, the pattern across multiple properties, the fake travel ban notice. I showed the metadata screenshots, the weather data cross-references, the certified mail receipts proving the timelines did not match. I explained how the surcharges and mystery fees were not in the covenants, and how the management company was processing them as legitimate, even though they were built on fraudulent timestamps. I said this was not a dispute over snow piles. It was a systematic scheme to extract money from homeowners using fake violations and procedural traps, and that Patricia had been running it for at least 2 years. Tom tried to interrupt. I kept talking. I said the board had a fiduciary duty to stop this immediately, refund the bogus fees, and investigate how the management company had enabled it. I said if they did not act, I would file a formal complaint with the state, and I would encourage every affected homeowner to do the same. One of the other board members, a woman named Helen, asked Patricia directly if the compliance logs were accurate. Patricia said the logs were generated by the management system and she had no control over timestamps. I said that was a lie, and I pulled up the compliance portal admin guide on my phone showing that board members with enforcement access could manually edit entry dates. Helen asked to see my phone. I handed it to her. She read the screen, and her face hardened. The room erupted. Homeowners started shouting questions. Someone demanded to know how much money the HOA had collected in fake fees. Someone else asked if the management company was getting kickbacks. Tom tried to restore order. Patricia stood up and said this was a coordinated attack and that I was manipulating records to cover my own non-compliance. I said I had the raw compliance portal logs, and I would be happy to provide them to an independent auditor. Tom said the board would take the matter under advisement and schedule a follow-up meeting. Helen said no. The board needed to address it tonight, and she moved to place Patricia on administrative leave pending an investigation. Another board member seconded. Tom called for a vote. It passed 4-1, with Patricia abstaining. Patricia said the vote was invalid because it was not on the agenda. Helen said executive authority allowed emergency personnel actions, and this qualified. Patricia grabbed her clipboard and walked out. The meeting continued for another hour. The board agreed to halt all active enforcement actions, freeze all outstanding fines pending review, and hire an independent auditor to examine the compliance logs and the management company's fee processing. Helen asked me to provide the full timeline and all supporting documents to the auditor. I said I would. Tom said the board would reconvene in 2 weeks to review the audit findings and decide on next steps. I asked what would happen to the lien threat on my property. Tom said it would be placed on hold immediately and removed entirely if the audit confirmed the violations were fraudulent. I said that was not good enough, and I wanted it in writing. Helen said she would draft the hold order that night and email it to me and the management company. I said thank you. I left the meeting and drove home through fresh snow. My phone buzzed with texts from other homeowners thanking me for speaking up and asking for copies of the timeline. I forwarded the documents to everyone who asked. Roger called me an hour later and said he had heard about the meeting from another client who lived in the neighborhood. He said I had done exactly the right thing and that the board was now on the hook to follow through or risk personal liability. He also said I should expect Patricia to retaliate and that I should document every interaction going forward. Patricia did retaliate. 2 days later, I received a certified letter from her personal attorney demanding that I retract my statements at the board meeting and issue a public apology for defamation. The letter claimed I had falsely accused her of fraud, damaged her reputation, and caused her severe emotional distress. It threatened a lawsuit for damages if I did not comply within 7 days. I forwarded the letter to Roger. He laughed and said it was a slap-suit bluff, and that I should ignore it unless I actually got served with a complaint. He said the timeline documentation was protected as evidence in a good faith dispute, and that Patricia would have to prove I made false statements knowingly, which she could not do because everything I said was backed by records. The auditor's report came back 10 days later. It confirmed everything. The compliance logs had been systematically backdated, the timestamps did not match the delivery records, the surcharges were not authorized by the covenants, and the management company had processed the fake fees without verification. The report also found that Patricia had used her board access to edit compliance entries for properties where owners had filed complaints or challenged violations, and that she had done this at least 18 times over 2 years. The total amount of fraudulent fees collected was over $30,000. The auditor recommended that the HOA immediately refund all affected owners, terminate the relationship with the management company, and refer Patricia's conduct to the state attorney general for possible criminal investigation. The board held an emergency meeting the next night. Patricia did not attend. The board voted unanimously to accept the auditor's findings, issue refunds to all affected owners, and terminate the management contract. Helen moved to remove Patricia from the design review board immediately and to refer her conduct to the county prosecutor. The motion passed. Tom said the HOA would also be sending a correction email retracting the smear and clarifying that all enforcement actions taken under Patricia's authority during the winter months were void. I attended the meeting and watched it happen. It felt like watching a building collapse in slow motion, every piece of Patricia's enforcement racket falling apart under the weight of the evidence. The refund checks went out 2 weeks later. I received $875, the full amount of the fraudulent fees plus accrued late charges. Every other affected homeowner received similar refunds. The correction email went out the same day, apologizing for the enforcement errors and explaining that the board had identified serious procedural failures and was taking corrective action. Patricia's name was not mentioned in the email, but everyone knew. But I was not done. I still wanted a face-to-face confrontation, a moment where Patricia had to answer for what she had done without a boardroom table or a lawyer to hide behind. I got that chance 3 weeks later, on the day of a scheduled dispute hearing that had been on the county court calendar since before the board meeting. The hearing was supposed to be a formality, a county magistrate reviewing my challenge to the HOA's lien threat, but Patricia had never withdrawn her filing, and the hearing date had not been canceled. I showed up at the courthouse with my binder and my timeline, ready to present everything to the magistrate if needed. Patricia was there. She was standing in the courthouse hallway near the hearing room, talking to a woman I assumed was her attorney. She saw me and her face went rigid. I walked up to her and said we needed to talk. She said she had nothing to say to me. I said that was fine, because I had plenty to say to her, and I was going to say it in front of the magistrate in about 10 minutes. Her attorney stepped between us and said I should not be approaching her client without counsel present. I said I was not approaching anyone. I was standing in a public hallway waiting for a hearing, and if Patricia wanted to avoid a public record of her fraud, she could withdraw the lien filing right now. Patricia tried to walk away. I pulled out my phone and held it up, screen showing a time-stamped video clip of her delivering the fake travel ban notice during the blizzard. The clip had been recorded by my doorbell camera and I had held it back until now, waiting for the right moment. I said I had not submitted this to the auditor because I wanted to save it for this exact situation, and that I was going to play it for the magistrate as proof that she had fabricated evidence and filed a fraudulent lien. Patricia stared at the phone, and her face went white. Her attorney grabbed her arm and pulled her aside. They talked in low voices for 2 minutes. Then the attorney came back and said they were withdrawing the lien filing and requesting a dismissal. I said not good enough. I said I wanted a stipulated order from the magistrate stating that the lien was withdrawn due to invalid underlying violations, and I wanted it entered into the public record so Patricia could not try this again with another homeowner. The attorney said that was not standard. I said then we would proceed with the hearing and I would present everything, including the video, the timeline, the audit report, and the board meeting minutes, and we could let the magistrate decide what was standard. The attorney looked at Patricia. Patricia nodded. The attorney said fine, they would agree to the stipulated order. We went into the hearing room. The magistrate reviewed the withdrawal motion and my proposed order. She asked Patricia's attorney if there was any objection. The attorney said no. The magistrate signed the order and dismissed the case. I walked out of the courthouse with the signed order in my hand and Patricia standing in the hallway behind me, silent and defeated. That was the last time I saw Patricia. The board formally removed her from all positions at a public meeting moment where the minutes turned against Karen, and she was told to step down and she cannot spin it. The HOA sent refund checks to every homeowner who had been hit in the enforcement wave, along with a letter apologizing for the procedural failures and explaining the corrective actions. The management company was fired and replaced with a new firm that implemented transparent compliance tracking and mandatory board oversight for all enforcement actions. The county prosecutor declined to file criminal charges, saying the conduct was more appropriately addressed through civil remedies, but the threat of prosecution was enough to ensure Patricia never came back. I kept my binder. I still have it, all 3 storms worth of documentation, sitting on a shelf in my office as a reminder that the paper trail wins if you are patient enough to build it. The neighborhood is quieter now. The new management company is professional and fair. The board is more careful about enforcement, and every time it snows I clear my driveway and take photos with timestamps. Just in case. I appreciate you spending your time with me, and I will be back soon.